So our business spotlight today is with Howard Wiens, with Lindley Mellon. Hey Howard.
Hey Larry.
Thanks for meeting me.
Thanks.
You know, Howard has been in business how long?
Oh, about 20 years now.
20 years. And you've got all kinds of experience behind your belt. One of the things that has come up a lot in our business, we chat with clients, is about wills, estates, and powers of attorney.
Sure.
Let's talk about power of attorney. What kind of tips would you want to give our clients to say, here's, safeguard you from these pitfalls?
Right, thanks Larry. I think one of the most misunderstood documents in the legal world is a power of attorney. So very briefly, a power of attorney is a document that you appoint someone else to make financial or legal decisions for you. Many people think it's just for old people, and it's probably most critical for old people, but where it can be really helpful is in a scenario where a husband and wife own a piece of property, or a house typically. They own it jointly, which is very, very common for a husband and wife to own a house jointly. What happens if one of them becomes mentally incompetent, or maybe even physically incompetent, the proverbial getting hit by a bus? So the husband gets hit by a bus or whatever, has a stroke, whatever language you want to use. It doesn't kill him, so we're not talking about the will yet, but they're incapable. And now the house that they live in isn't useful for them anymore. They can't live there. It's got too many stairs. It's not close enough to the hospital. Whatever, it doesn't matter. Can the wife just sell the house? And the answer is no, she can't. There has to be a power of attorney. The husband has to have given the wife a power of attorney and vice versa so that she can sell the house. So I think one of the things that we always encourage clients whenever they're buying a home jointly, which is often, is that they at least think about giving a power of attorney to each other so that the husband has it for the wife and the wife has it for the husband. This way, if one of these events happen, and we don't hope they do, obviously, but if one of them does happen, we've got a solution in place.
Great. You know, I've been just working recently with somebody who says, yeah, you know, we've got power of attorney over that situation. And meanwhile, it's only for a bank and the bank accounts, and it's not for real property. Talk about that, because there is some misconceptions out there with power of attorney.
Yeah, there are. So when I hear people say that, that usually means that they've gone to their bank and the bank has given them a power of attorney that's just typically exclusively for the bank. So the Royal Bank will have the Royal Bank power of attorney. It can't be used anywhere else. It can't be used at Scotiabank, can't be used at the Land Title Office, can't be used at the Motor Vehicle Branch. It's just for the Royal Bank. So when you get a power of attorney from a lawyer, typically, it's what we would call an enduring power of attorney, and it's useful anywhere for any purpose. And that's the kind of power of attorney you're going to want for this scenario.
We have a few clients in the last few months that have tried to do probate on their own.
Yeah.
And I'm getting calls weekly. And I'm a realtor, I don't know anything about probate.
Right.
What do we need to know about probate, and why would somebody want to do it on their own?
Well,
that's a good question.
I know the answer to that question is very easy. The reason they want to do it on their own is because they're going to save some money.
But it's not a lot.
But here's the thing with probate. There are statistics on this, and the statistics tell us, and this is from the probate registry at the Supreme Court of British Columbia. So the statistics would tell us that of all the probate applications the Supreme Court receives, about 75% are prepared by lawyers and about 25% are prepared by lay people. Okay? Of the 25% that are prepared by lay people, approximately half of those, the layperson throws up their hands about halfway through and says, this is way too complicated, I cannot do this on my own, and it ends up being completed by a lawyer. So what that tells you is that there is a percentage of people that are going to be able to do this on their own, but it's a relatively small percentage because it is complicated work. This is not simple work. The number of documents, affidavits, declarations, disclosures that the court requires to do a probate is, well, let's use the word several. There's lots of them, and they have to be done perfectly. And if they're not done perfectly, you're going to get rejected and come back and come back and come back. So typically, most clients will hire a lawyer to get a probate application done. Cost can be all over the map. If I were to start and give a ballpark number, $3,000 would be a rough guesstimate as to what it might cost, but that can go all over the map on a lot of different factors. But that's what it looks like. Probate, it's not something you can avoid. By hiring a lawyer, doing it yourself, you're not going to save on probate fees. That's still going to be the same regardless. So maybe this is a bit self-serving again, perhaps, but if you want this to be smooth with as few headaches as possible, it only makes sense to hire a professional to get a probate application done.
So, the last is the will.
Yes.
Most people have wills, some don't. Do we all need wills?
Right. Well, my first comment on that one, Larry, is I'm probably going to push back a little when you say most people have wills. Most people at our age have wills. Most people, yeah, you and I, we probably have wills. Most people under the age of 40 do not have wills. In fact, the vast majority of people under 40 do not have wills. Is it important to have a will? And the answer is yes, it is important to have a will. Particularly if you're a couple who owns a home and you don't own it jointly, then it's imperative that you get a will. You need to have a will to make sure that the right person inherits what you own. Typically that's intended to be your spouse. But it's also really critical to deal with issues like what if both you and your spouse die together and you have children? Who's going to raise them? How is the person who's raising them going to get paid to raise them? And I don't mean that they make an income off this, but get reimbursed. At what age will your children receive the inheritance? Do you want them just to get a lump sum when they turn 19, or do you want them to wait maybe a little more? These are some of the issues that need to be dealt with in a will. And finally, we also need to deal with the question of what if the whole family dies in one catastrophe? And that's not something we want to think about, but it is something, unfortunately, we have to think about a little bit. So these are the issues that need to be dealt with, and it's just good financial planning for anybody. And if you've got the wherewithal to buy a home, you have the wherewithal to do a little bit of financial planning.
Say today, just want to thank Howard Wiens, Lindy Wellwood. If you're looking to maybe have a conversation with Howard, I'm going to put up his phone number here at the office, and you can talk with him further, set up some appointments, figure your life out. Wills, estates, real estate. Thanks a lot, Howard.
Thank you, Larry.